What you're about to see isn't political theater. It's a real-time test of whether a nominee is actually qualified to wield federal power, and the answers may shock you.
Senator Whitehouse.
Thanks very much. Mr. Donahue, what is the maximum number of lawyers that you have supervised in your experience as an associate in a law firm?
Thank you for your question, Senator. It varies, but it was typically anywhere from 6, usually 8, up to 10 with summer associates as well.
All lawyers?
Not all lawyers, including summer associates.
Okay. What was the maximum number of lawyers you supervised in your job at the solar company?
None, Senator. Not at the solar company.
In your work as an associate in the Buffalo law firm, did you hold yourself out as an environmental attorney?
As an environmental lawyer, I did.
You spent 1 year and 6 months practicing law for that firm in Buffalo, correct?
I was located in that firm in Buffalo, yes, Senator.
Yeah. And you were terminated by that firm after 1 year and 6 months?
That is correct, Senator. If I may just add some color to that.
Well, I have pretty short time, so we can follow up with QFRs, because I promise you there'll be QFRs
Understood.
on this. Have you practiced law anywhere else other than that as an associate in the firm that terminated you and in the solar company where you supervised no lawyers?
Senator, I have not.
Apart from your associate experience in Buffalo and the solar company, have you practiced law in any other place?
I have not, Senator, but I was at the agency before in the first Trump administration.
Not in a legal position?
That's correct, Senator.
Have you ever taken a deposition?
I have not, Senator. This is probably the closest I've ever come to that.
Have you ever tried a case to verdict?
No, Senator. In the firm and at the solar company, we relied on, in the solar company, we relied on outside counsel.
So you were providing inside advice at the solar council rather than active litigation work?
It was an in-house counsel role, yes. But
Yep. Have you ever argued a motion?
I have not, Senator.
Court?
But as you
know what a motion in limine is?
I do vaguely, yes.
Well, you should have been better prepped, because John Kennedy asks this question.
Yes.
Have you ever authored and signed a legal pleading?
I have not, Senator. But
there was a gap of several years between your graduation from law school and when you entered the bar in Washington, D.C. During that period, did you take the bar and fail to pass?
I did one time, Senator, yes, but
In
there
what
was
jurisdiction?
What, sorry?
In what jurisdiction did you take the bar and
Washington,
fail to
D.C.,
pass?
Senator, but there was a gap before I actually took the bar. I wasn't sure if I actually wanted to go and practice law, to be frank with you.
Under what circumstances would you counsel the EPA administrator to violate a court order?
Senator, thank you for that. I would never counsel the EPA administrator to violate a court order.
Under oath, can you assure us now that EPA is presently in compliance with the federal court decisions by Judge Ali Khan and Judge McConnell right now?
Senator, I believe that the agency is.
When a public official makes public accusations of criminal activity with no credible evidence to support the accusations, what legal liabilities and concerns does that raise?
Senator, as you mentioned in opening, potentially defamation, that sort of thing. But I'm not a criminal investigator. I'm not at the Department of Justice. I don't handle the various aspects of that criminal probe, so I'm not privy to that information.
There is an internal memorandum out of the agency's counsel office that relates that a significant number of grants were terminated based on a significant error, agency's words, in the terms and conditions for those grants. As the Washington Post reported today, an agency lawyer warned officials that they had cited contractual language that did not apply to many of the grants the EPA had ended in recent weeks. Grants had been terminated on grounds that they no longer fit the agency's priorities, referring to a clause in their grants general terms and conditions that applied only to grants issued between August 13, 2020 and September 30, 2024, and almost half of the terminated grants were finalized outside of that relevant period. Have the grants impacted by this significant legal error been restored to the recipients?
Senator, I've seen the reporting on that. We received your letter, in fact, 2 letters yesterday on this. I was not on that email. I think it was an email, not a memorandum, but I think we're working to track an answer down for you on that.
My time has expired.
What made this exchange so powerful wasn't the sharpness of the questions alone. It was what those questions revealed about how government power is supposed to work, and what happens when the people entrusted with it aren't prepared for the responsibility. Senator Sheldon Whitehouse wasn't trying to score a viral moment. He was doing something far more consequential, stress testing whether this nominee could actually function as a legal authority inside one of the most powerful regulatory agencies in the federal government. And the reason that matters is simple. The EPA doesn't just write rules, it enforces them, defends them in court, and is legally bound to comply with federal judges when it loses. That's why Whitehouse's questions followed a deliberate path. He wasn't asking trivia, he was mapping experience. Supervising lawyers matters because it shows whether someone understands how legal teams operate under pressure. Depositions matter because they test your ability to extract truth under oath. Trials matter because they expose you to evidentiary rules, judicial authority, and real consequences when mistakes are made. Motions matter because that's where legal arguments live or die. Each no wasn't just an absence of experience, it was another missing layer of legal muscle. And as those answers stacked up, viewers learned something important. Being adjacent to law is not the same as practicing law. Titles can sound impressive, but they don't substitute for time spent defending decisions in front of a judge who can shut your entire operation down with a ruling. The bar exam moment landed hard, not because failing once is disqualifying, many good lawyers stumble early, but because it came alongside a record that never showed recovery. No litigation experience followed, no courtroom growth, no evidence that the gaps were ever filled. What remained was a resume that leaned heavily on proximity to power rather than tested competence. Then the hearing turned from qualifications to consequences. When Whitehouse raised the issue of terminated EPA grants, this stopped being theoretical. Billions of dollars were pulled back from communities, projects, and programs based on legal justifications that, according to internal agency lawyers, didn't actually apply. That's not a political disagreement, that's a legal exposure. Here's what Americans may not realize. When an agency cancels grants without valid authority, it doesn't just risk embarrassment, it risks injunctions, damages, loss of public trust, and long-term constraints on what the agency can do in the future. Courts remember when agencies cut corners, and when judges lose confidence, agencies lose discretion. That's why Whitehouse pressed on court orders. Advising an administrator to comply with a judge isn't optional, it's foundational. And when asked whether grants terminated due to a significant legal error had been restored, the uncertainty in the answer said more than any argument could. If leadership doesn't know whether unlawful actions have been corrected, accountability has already slipped. What this hearing teaches, beyond the headlines, is how fragile the rule of law becomes when expertise is treated as optional. Agencies don't operate on vibes or loyalty, they operate on statutes, precedent, and judicial oversight. When those at the top lack grounding in that reality, the public pays the price through delays, reversals, and weakened protections. This wasn't about humiliation, it was about prevention. Preventing unlawful actions before courts step in, preventing billions in public funds from being mishandled, preventing agencies from drifting into a culture where legal rigor is replaced by political convenience. If you want a government that actually works, one that respects courts, follows the law, and earns public trust, these are the moments that matter. Share this, stay engaged, and keep watching closely. Accountability doesn't end when the hearing gavel drops.